ago when this is probably in the maybe early '90s, late '80s. I was in the Rotary Club, Bryan Rotary Club, and I'm standing in line. There's
Yeah,
Okay.
I bought this one day.
It's 9:03, so we're going to call this Commissioners Court for a public hearing Tuesday, February 24th, 9 a.m. Commissioners Courtroom, County Administration Building, 200 South Texas Avenue, Suite 106. Commissioners Court will hold a public hearing on the guidelines and criteria for granting Chapter 312 tax abatement in Brazos County. All interested parties are invited to attend said hearing and present their cause, if any, for or against proposed guidelines and criteria. I'll turn it over to Kimberly.
Good morning, Judge and Commissioners. Kimberly Gonzalez, Brazos County Economic Development Coordinator. Today, we are here for the public hearing for the Chapter 312 Economic Development Guidelines. In accordance with Chapter 312 of the Texas Tax Code, counties are required to adopt tax abatement guidelines every 2 years to enter into tax abatement agreements. Today's public hearing is to hear any comments from the public regarding the proposed guidelines. Per public notice requirements, a notice of this public hearing was placed in the Eagle on Saturday, February 7th, 2026 to meet our 7-day notice requirement. For good measure, the notice was also posted outside of the Brazos County Courthouse, as well as on the Brazos County website on Monday, February 2nd, 2026. On Tuesday, January 27th, I presented to the court our current tax abatement guidelines, along with proposed changes in a public hearing. I took the changes presented by staff during this public hearing, along with the requests made by the Commissioners Court during the public hearing to update our new guidelines, along with the help of legal. The new guidelines were sent to the court on Monday, February 16th, along with a one-page summary sheet for review. Both documents have also been included as backup for both this morning's public hearing and for the regularly scheduled meeting at 10 a.m. The updated guidelines presented for consideration today reflect statutory requirements, incorporate revisions to strengthen oversight and consistency, and if approved by the Commissioners Court with a 3/4 vote of the court. So we have 5 of you here, so at 10 o'clock we'll need a vote of 4 of 5 to pass these guidelines. If they are approved at our regularly scheduled 10 o'clock meeting today, they will remain in effect until through February 24th, 2028, unless the court decides to amend them otherwise. With all of that being said, I am happy to answer any questions that the public or the court may have regarding the guidelines.
Okay. Have any questions?
None for me.
On the first page, 1 of 11, it says Brazos County must compete with other localities. That should be may, because we don't have to compete with anybody if we don't want to.
That's true.
So why would we put must in there? Kimberly?
It's sort of semantics, right? So we must compete with other localities, as in we must compete with other states.
We don't have to. So why would we put must? Why don't we just put may? We may, if we decide to, compete with other localities and other states.
I'm happy to change that if the court wants to change that and push it out 2 weeks.
If you want to, when it comes up in a regular agenda today, you could motion to approve with the change of.
Okay. Yeah. Okay.
Got anything else?
Oh, no, sir.
Okay.
Thank you.
Any other comments, questions from the court? Do I hear anybody from the public? It's a public hearing. Kathy Beans, come on up.
Good morning, Judge, Commissioners. I did have a question about some of the language here. And as you might recall, the last time we discussed this, I requested that the court consider excluding data centers from abatements. And I don't see that language in here. I do see an exclusion for the sex trafficking trade or whatever, you know what I mean. But I would like it to be added in there to specifically disallow data centers. And failing that, I would like to know if the wording here when it says that the planned or potential use of the property would constitute a hazard to public safety. I'm on page 5 of 11. It's at the top, C. And then D, planned or potential use of the property could create adverse impacts to adjacent properties. I was wondering if that could be defined, I mean, if the data center would fall under those definitions?
So, I mean, I have talked with, I mean, we've got data centers around Texas and around the nation, and some of them are potentially hazardous. But I've talked to some of these guys, and they say that with the newest technology, that they've come up with a cooling system that does not use water like groundwater, like we all would be concerned about. And they're not as, they don't use as much electricity because they've gotten more efficient. So my concern about saying we're just gonna exclude them totally would be, you know, it might be some data center that actually may have merit and does not impact us negatively. And at least if we leave it open to that, then we don't have to do anything. We don't have to give them a tax abatement. But leaving it open because technology certainly changes, and it's changing rapidly in data.
Well, if I understand correctly, this is only for 2 years, so I would still ask that it be excluded for the next 2 years, that it's not just water, it's not just electricity, it's also the sound impact on the surrounding communities. And I'm going to guess that it's going to be in the Rellis area, and there's a lot of development up in that area, so it will adversely affect the residents there for sound alone. So I would ask that it be excluded in this 2-year agreement and then reconsidered in 2 years from now. And in absence of that, can you tell me if the sound effect on the neighboring residents by itself would be included in this exclusionary wording?
So I think that may be a legal issue. I know that we can't prohibit industry from coming into our county, even if we don't like them. I know that. And I think the exclusions come from the statute.
Well, I'm not
sure.
asking you to exclude a data center per se. I'm asking that we not consider them for tax abatements. You're going to impact the residents. Why should we have to diminish our tax revenues in exchange for the quality of our life being diminished?
I don't
So
know
can
the
we
answer.
use that language? If it affects the sound and the quality of life, can't we use this wording if you're not willing to exclude data centers from tax abatements specifically? Yes.
Commissioners, in reviewing other guidelines from other comparable counties, I have not seen an exclusion for data centers. That's not to say that they don't exist. They certainly may be out there. As Commissioner Nettles mentioned, we do not have the authority to not allow a data center into our county under the statute. We don't. We can decide not to give them a tax abatement. However, by not writing specifically into our guidelines, if we write specifically into our guidelines that no data centers are allowed, it ties the hands of the court if there is a data center that moves onto the Rellis property. So the court has the discretion to decide on a case-by-case basis. So if a data center happens to want to move here and they come to the court, you have the ability to say, no, this is going to have a negative impact on our surrounding community. If you write that into the guidelines that no data centers are allowed, it ties your hands, and it kind of removes a bit of that discretion to decide on a case-by-case basis. If the court, go ahead.
And in the case of a data center moving to Rellis campus, we really don't have any say-so.
We have
Our only say-so is whether we give them any tax abatement at all.
Right.
But as far as them moving there, we can't say no.
No, we have no control over that.
That's right.
We're not able to dictate what somebody does with, property rights is property rights, and that's a big deal for nationwide, statewide.
To the concern, though, that I share, with data centers being required to produce their own electricity, of course, with small modular nuclear reactors being developed in Rellis, That could be a thing. Like, I mean, I don't know if it's in the next 2 years, but that could be a thing where a data center actually provides its own power, or they generate it another way. The lower water use that's technology that I'm excited to see, because we cannot afford to dump a bunch of water on a data center.
No.
The sound, where previously it was looked at near neighborhoods, I think that the court, I can't speak and I haven't violated any open meetings, but I'll bet you this court would not have gone forward with that either, just like College Station did not. But, so ultimately you can approve or not approve an abatement. This policy precluding things from coming, especially things that we can't, for statute, keep from coming, like a data center. We certainly don't need to give a tax abatement to someone that doesn't satisfy concerns of community, being a good neighbor. And I think that the day that data centers are good neighbors are coming, but I wouldn't want to preclude per se in this policy a data center. We can certainly opt not to give them a tax abatement, which is what this is about. And yeah,
That's exactly what I'm asking
Yeah.
for, though. And I understand your point that it's tying the court's hands and not allowing them to give a tax abatement. But I would bet you any amount of money that the residents in this county would support you having your hands tied against offering abatements on data centers. I think if you surveyed people, if it was on the ballot, they would say absolutely no tax abatements for a data center. We all understand about the property rights and that data centers are probably going to come in, but I am asking the court to restrain itself by changing this agreement to exclude a data center from receiving a tax abatement at the taxpayer's expense.
And to your point, Kathy, if you think about it, oh yeah, I do have a mic on. To your point, I think the resistance to data centers has become so prominent in so many communities. I would hope that even if Relish was considering bringing one in, that the consideration would be for the surrounding area, as to your point, because we know that West Bryan is starting to grow all around that, and so the resistance for those data centers is so up front and prominent with the discussion, that I would hope that in any consideration, if Relish were to do so, being good neighbors would be at the forefront of any decision that they make, because there is such resistance, and it's so unpopular that I hope they'll make good decisions if that is to happen in Brazos County.
I still think it would be a show of good faith if the court were to show its restriction of its own abatement offers to data centers. I think it would be reassuring to the constituents and the citizens in the county that you do not intend to promote it by offering tax abatements. Thank you.
Thank you. Any other, Cindy?
So I had a couple of concerns, Cindy Wiley, Precinct 1, or Commissioner Court, Precinct 1, regarding the language and the lack of transparency in some of the wording. I do agree with Commissioner Brown on the use of the word must. I do not think that is a word that should be put into this agreement, since you guys do have the decision-making power to give or not give a tax abatement. Another question I had was regarding 3/4 of 5 voters. I think the language actually needs to be relative, which is 4/5 voting majority, and the contract does not reflect that. It says 3/4. Also, on page 4, 7A, who will be determining the substantial adverse effect? What people will be responsible for making that determination? It's undefined. And then again on page 5, 7D, also, who will be the people that will be determining the adverse impact? And I believe that has to do with the properties. Then again on page 7B, who are the agents and the representatives who may or may not do a an impact study, and who may or may not be required, the applicant may or may not be required to pay for the impact study. It's very wishy-washy. And who would do the study? Who's going to determine who is the person or the organization that's going to do the study? It's undefined. Also, a concern I have, or just clarification for me. So a reinvestment zone actually is created after the county is assured that the applicant is wanting to engage in the tax abatement agreement, as opposed to the other way around. A reinvestment zone actually exists, and an applicant decides that's where they want to build their business. So that just seemed like putting the cart before the horse to me. And another thing that just, to me, just doing a cursory read of this, it just seems like the undercurrent that's speaking in this agreement is that the only asset or attribute that Brazos County has to offer an incentive for a company to come here is a tax abatement, because it promotes nothing else. It doesn't talk about our culture. It doesn't talk about our labor, our schooling. It doesn't talk about anything other than the fact that you guys have the ability to throttle down their tax advantage, or to increase their tax advantage if they come here. It just seems like you cheapen our county, to me. That's my opinion. Thank you.
Okay, well, this is a 312. I mean, it's all about tax abatement. That's really all it is to kind of set guidelines, which are required by the state to have in place every 2 years. So it's not like, I mean, I understand that we've got a lot of things, a lot of reasons why a company may want to come here other than a tax abatement. And in my opinion, that's what they look at first. The tax abatement should be the last thing that when they're looking at Brazos County, our community. If the first thing they look at is a tax abatement, then I don't know that we want to even consider them, because there ought to be plenty. There's plenty of reasons why we're a good community, and they may want to come here. A lot of it may be in Texas A&M, but you have to have this in place. It's state law. You have to have the 312 in place, and that's really all it deals with is tax abatement. Doesn't deal with all the other reasons that somebody may want to come here.
And let me just say, Cindy, anytime, whether if, for example, if you're just an individual moving here for a job, you're talking about moving your family here. In the discussions that I've had the privilege of sitting in on, quality of life does come up, because people want to know about the schools, they want to know about activities and things. What does this community have to offer? If we're going to move a company here, and especially if we're going to uproot our employees and move them to a community, quality of life is always a part of the discussion. As an individual, as a company, and so the county has really nothing to do with that, except for the fact that, just like you hear Destination Bryan and all of the things that both cities do, consideration for what does this town have to offer a company or an individual or a family that moves here. That's an automatic discussion. If a company, just like we're vetting a company, they're vetting our community. So those things wouldn't necessarily be built into this. That is a part of the discussion from my vantage point of, do you want to come to this community? Whether you're a company or whether you're an individual, you're going to look at quality of life in addition to what can we get, whether it's a tax abatement. But is this a community that our staff can also survive and thrive in? And that's quality of life. And that's being promoted all the time. When you hear Brian in College Station and City talk about moving company, trying to bring companies here, that is almost like a packet that they're going to prepare. Here are the things that we have to offer. That has nothing to do with this in a sense, because they're going to look at that even as they consider whether or not we're going to try to ask for a tax abatement.
Okay, thank you. But I don't want what my last comment was about this community to overshadow my earlier comments about the lack of transparency that I addressed in my speaking about what's in this contract, about the adverse impact, about the study, who's doing it, and who are the agents, who are the representatives. So please, don't just get stuck on what I said at the end. Thank you.
I will try to address all the comments that were made by Ms. Wiley.
Can I make one more before you proceed, so you can include mine in that too?
Sure. Yes, I would love to do that.
And this is nitpicky. I did real well in English in school. I did not do well in math, so don't ask me any math questions. But on page 7 of 11, number D, it says, having completed all the required steps in the process and having been assured by the applicant that it wishes to proceed. Can we change that to chooses to proceed? And
I'm
then
sorry, what page was that on, Commissioner?
7 of 11, item D. Where it says wishes to proceed?
Yes.
Can we change that to chooses to proceed? And then also in E, the bottom sentence, wishes to be considered. Can we change that to chooses to be?
Which, are you still on page 7?
Yes,
Under,
D and E.
I don't see an E on,
Page 7E.
I'm on the wrong guidelines. That's why I don't see it. Yes, I'm happy to do that.
Okay. I think it just sounds more professional. And I guess we could ask our attorney down there at the end.
Okay, so when it comes to the comment about the 3/4 vote, that is statutory language. So I took the statutory language and included it in our guidelines. That's why I didn't say 4 or 5 commissioners or 3 or 4. 3/4 vote is how it's written by the state. So that's what I used. When it comes to our application process, and I'm happy to sit down actually with anybody who would like to sit down and read through our application that we have. I don't have one in front of me, but there are a number of requirements that a company must submit when they are wanting to apply for a tax abatement. Among those are environmental studies, financial pro formas. We request, I think it's 3 years to show that the company has a record for their finances. And then when it comes to who would perform the study, if there's an environmental study needed or an impact study needed, that would be on the company to pay for. That's why it's written the way it is. The company would have to pay for that, and usually they would use an outside consultant, and then they'll provide that to the county. When it talks about the representative, I am the representative for the Commissioner's Court. I'm under the county judge, but I report to the court as well. I'm the one who vets all the applications, and I review all the documentation. It is very common for me. I always sit down with legal. I very often sit down with audit to discuss the applications on a case-by-case basis. And then that is compiled. And if I see that something is not in their application, I'm always going back to the company requesting it before I bring it to the Commissioner's Court for an actual determination of whether or not the court would wish to decide, the court would wish to incentivize the company. I'm not sure what else I missed. in the comments that were made. I'm happy to change the chooses to wishes, and then the must to may that you mentioned, Commissioner Brown. If the court does pass these at 10 o'clock, we can make that with the changes that we mentioned here today. If not, this is going to push this process out, potentially 3 or 4 weeks. So there will be a couple of weeks where we may not have Chapter 312 guidelines. But that's up to the court to decide if it's not passed today. And just as a reminder, they can be amended with a vote of the Commissioners Court in between the 2-year period.
What is the downside of this being pushed out 3 or 4 weeks? Is there any downside? I mean,
The court won't be able to enter into tax abatement agreements, and we do have one that's slated for the month of March.
okay.
How many total agreements do we have in place?
I have that.
And we have an agreement with a data center, is that correct?
We do have an agreement with a data center.
So I'm wondering if we pass this and put the data center in that, how that impacts our ability to renew that or continue in that agreement. And it's on the far side of Rellis with no one around it, so I don't know anybody's complaining. At least no one's come to the court to complain.
There are currently, well, that's 381s. We have 4 312 agreements in place. And we should cross 5 in the month of March if the court approves it. But currently we have 4.
Okay. Any other comments from the court? Kathy?
I apologize. I did not quite hear what she said. There's already a data center agreement in process? Is that true? Is that what I misheard?
There's a data center agreement for a project on the Rellis campus.
And what's the status of that right now with the city of Bryan?
With the city of Bryan?
Yes.
What do you mean?
Have they approved the construction of a data center on Rellis?
Yes. The city of Bryan does not approve projects that occur on Rellis. The Texas A&M University system has approved construction of a data center.
Okay, so then they have applied for an abatement from the county for that data center already? It's in process with the county?
Yes, it's been in place for probably 2 years.
So for the purpose of transparency, nobody here has mentioned that to me. Yeah?
Can I get the mic, please? Thank you. That was presented in the fall when I do compliance reporting. That Chapter 312 agreement is presented, and it was presented in October when I did our annual compliance report. So it has been made public. We were required to do all of our public comment, all of our public notices, and the designation of a reinvestment zone, which I remember another comment, you cannot enter into a 312 agreement until you have a reinvestment zone. So that's why we don't do a reinvestment zone. That's why the order is the way it is. You have to have a reinvestment zone to enter into a 312. So that's your first step to even have one of these agreements. But that 312 agreement was presented in October.
So you all knew about this all the time. I've been coming up to you asking about data centers and nobody ever mentioned it. And so for the effort of transparency, which has been my motivating drive of coming to court for the last 3 years, is for transparency. And when we come to the podium and we misspeak or we say something that's not true, you commissioners are supposed to correct us for the factual errors. And so I feel really affronted and insulted that I've been asking you about data centers. Nobody said that we've already approved one or that's already in process, and I feel like that's a huge lack of transparency to the public and to me.
I hate that you feel that way. We're talking about moving forward the next 2 years, what the county does. You were at the October meeting when we discussed the update on current agreements. I hate that you feel that way. especially when this court is listening and trying to be transparent with things that are asked of us.
Do you remember me asking about this last month?
I remember you about what?
Data centers and the prospect of this vote today
Right.
to include the exclusion of data centers, and nobody said we already have one in process.
So,
I feel like that would have been the perfect time for you to have said that.
yeah, so what I remember was public comment last time when you mentioned this, right?
I don't recall.
Where we can't respond. But additionally, today's action is about the future, the next 2 years of the county policy. So I didn't think it was apropos to respond to something that had already been presented with you present about.
I don't
a
remember it
current-
specifically
And
being a
that's
data
okay, there's a lot
center.
that goes on here,
Yeah.
but I reject your implication of us trying to, I actually didn't reject, I'm sad to hear that you're insulted. I really am, because this was all public. I hate that you feel the way you do, and I can't take that away. You feel that way, that's fine. We're trying our best to handle a lot of business and a lot of money and a lot of agreements for the people that put us up here. And it breaks my heart to hear that you're insulted by this, because this has all been handled publicly here in this room, where you, to your point, have been here for 3 years. So I hope that you understand today's action is about the coming 2 years, not a review of everything that's happened. That was done in October. I understand how that might seem the way that you're taking it, and I'm sad to hear it.
Well, I guess my point here at the podium has been moot, since the camel's nose is already under the tent and the court has already approved these. So thank you.
Thank
No, I
you.
think actually your comments are well noted, to be
Yes.
honest with you, because I think we all have concerns about data centers. That particular agreement wasn't very successful for the county.
No.
So I hear what you're saying, but I'm not sure that we can actually put this in the guidelines. But I do think it should be more closely, as all. I look at these agreements as a gamble. It's a gamble on future revenue streams for the county. If we're going to give these things to industry, we want them to make sure that they're going to succeed, they're going to bring jobs, and there's going to be future taxpayers in our county. That's the only reason I see of doing it, unless there's some other motivation I'm not aware of. So I'm not sure data centers in the current environment meet that, but also I'm not sure we should exclude them, because the technology is changing so quickly over the next 2 years. I hate to hamstring future courts, which I'm constantly looking at, well, how do we do business here? Where is it written down? Are we making it up as we go along? And so I'm in favor of us having guidelines, which the law requires us to, but favor of having guidelines on a lot of things, like workshops. But we need to move forward with those things so that it's transparent to everybody. And I agree. I'm sorry that you felt like we hid that from you. We've been schooled not to speak back during public comment. I don't agree with that, but that's what the law says, and I'm not willing to have a criminal misdemeanor charged against me by the district attorney if I violate the Open Meetings Act. So, my phone, I mean, I'm here all the time. You have questions, please come ask. There are just things we can't necessarily address outside in a normal meeting. We can do in workshops, and I'm glad we're having this workshop, so you raise those concerns. And I take them as very valid. I don't want you to think that we're not considering them.
Yes.
I'd like to add also that whether we approved a tax abatement on this Relis campus data center, whether we approved it or not, they were gonna come.
Yep.
So do we get part of something or part of nothing? That's what the question was. But whatever happens on Relis campus is gonna happen
Right.
with or without us. So we need to understand that going forward.
Okay. Any other questions, discussion from the court? All right,
Sorry, Judge.
come up.
Just for the record, I asked Jennifer to please clarify, I'm sorry, your name is Jennifer,
Kimberly.
isn't it?
Kimberly.
Kimberly, sorry. Page 7D. Having completed all the required steps in the process and having been assured by the applicant that it wishes to proceed, the county may then follow procedures in accordance with the Texas Tax Code, Chapter 312, and establish a reinvestment zone and tax abatement agreement. So the way I read this is that first, the county is assured that the applicant wants to go forward, then a reinvestment zone and tax abatement agreement are entered into after that fact. But that's not what I heard Kimberly say. So, just point of clarification.
I don't recall the exact wording I used, but the wording that is included in here is correct. There's an application submitted first. Once we know that the company actually intends to be here, and usually once they submit an application and an application fee, we have a good feel that they would like to be here. Once the court decides whether or not they wish to incentivize the company, that's when the reinvestment zone procedures begin. If the company is located in the city limits, the cities undertake the reinvestment zone. If it's in the county's jurisdiction, the county does the reinvestment zone, and then we enter into all of the 312 agreements, which require all of the state posting requirements.
Well, and it's a possibility that the reinvestment zone has already been created that this company may decide they want to move into, so it might
Yes.
already exist.
Yes, so especially on Relish, they have 3 or 4 reinvestment zones there already. So sometimes that step's already done, and that saves us about 30 days, 7 days. There's different notice requirements for every step, so.
Okay, thank you, Kimberly. All right, we're gonna close this public hearing. It's 9:39. And now we've got a